matters? Of course it does. Welcome once again. I'm Debbie Morais, your host and moderator. This long-running program continues to provide legal information, relevant examples, and practical assistance to help you with the law matters because the law matters. A better understanding of the law makes you better prepared to decide how to protect yourself, your family, and your business. As we present various topics, you may decide, as we've told you, to handle some yourself. If you do decide to enlist professional counsel, you'll be better prepared to work with the professional you select. Our goal always is to save you time, money, and hopefully to achieve the best possible results. As always, too, we welcome and thank once again Attorney David Bazar from the Bazar & Associates law firm in East Providence as he continues to offer his legal information and insights on the various issues that we tackle. Today we'll discuss the differences between personal injury and workers' compensation cases and how those distinctions matter to you. We'll be exploring some specific circumstances and injuries that happen on the job. How does working at home now impact workers' compensation and the ability to prove those cases? What are the considerations for comparing and deciding how you're going to proceed? Sometimes it can mean the difference between hundreds, thousands, even $500,000. How do you prove all of these things and how should you proceed? What do you need to know if you're an employer, an employee, and what do you do if your claims are denied? All of these things, turns out, are complicated. So let's start with David with a brief tutorial, I guess, on personal injury and workers' comp, and I think we're going to be putting this in the context of a work environment situation.
Sure.
But
so at the beginning of the Industrial Revolution, when people were working in factories and you would have an injury, in common law, in order to recover for that injury, you would have to prove that someone was negligent. And in order to do that, you had to prove that there was a duty owed to you and that someone breached that duty. And oftentimes, like today, you would have to go to court to prove that case, and it would take time. And in the meantime, you were hurt, you can't work, and you're unable to pay for your bills. So at some point, the government decided, the legislature, to create the remedy of workers' compensation. And so what they did was, if you were hurt at work, so what you needed to prove was that your injury was the result of your work, in the course of and out of your work, and you were no longer able to work and recover and make money. They said, okay, we're going to create this system where you can recover money quicker. And you didn't have to prove that you were hurt as the result of somebody's mistake or negligence. You just had to prove that you were hurt at work and that you could no longer perform the duties of your job. And if you're able to do that, then you would get a percentage of your income and your medical bills covered, but you wouldn't be able to sue your employer for pain and suffering and the other things that usually flow from a personal injury case. So your remedy is limited, but you would recover much quicker. And that was a trade-off that was put in place. So there was a shield of liability for common law cases against your employer and your co-employees as long as the injury was a result of your work.
that was designed to be a win-win for the employer to put a cap on things and help his employee, also keep him from getting sued. When it comes to personal injury in the workplace, how does that fit in? There are times when the cases can coexist. Give us a little bit of a context about that, if you would.
Sure. So let's just take an example of somebody who was a visiting nurse. So you're driving from one job to the next, you're on the clock, you're in the course of your business, you're between patients that you're going to see or clients, and you get rear-ended at a red light. So are you entitled to collect workers' compensation? The answer is yes. You were in the course of your employment, so you can collect money from workers' compensation, which again would be your medical bills and a percentage of your wages that you're no longer able to earn. However, this is what's called a third-party case. The person who hit you is not your co-employee, it's not your employer, so you're entitled to sue them for the damages that they caused, so that we don't have what would be called double dipping. If you recover from the third-party tortfeasor, the workers' compensation insurance company, usually because your employer usually insures their workers' compensation claims rather than being self-insured. But either way, whoever paid the workers' comp is entitled to be compensated for what they paid you already. And the tortfeasor therefore pays your entire amount of damages, but so that there's not a double recovery, whatever you've already been compensated would get paid back to your workers' compensation insurer or employee.
So
Employer.
what I glean from what you're saying there is when you're talking about the distinctions between the two, one is a fault, no fault situation. Also, personal injury lets you have pain and suffering and all that. Workers' compensation, I believe, it just doesn't really deal with that. So when someone is in a situation where, gee, is this really personal injury, and do I have to prove fault? Or should I just go the workers' compensation route because that's, I don't know, free? Not free, but easy to just wrap up. How do people proceed with that, and what should they do?
So if you're hurt at work or in the course of your employment, you are entitled to workers' compensation. If the injury was caused by some other party other than your employer or a co-employee, then you are entitled to both. And so, again, like I said before, there's not a double recovery because your wages that you recovered are going to get paid back to the extent that they were paid. Now remember, workers' compensation only pays you a percentage of your wages. You're entitled to all your wages on that third-party case, and you're entitled to pain and suffering. So you're entitled to collect more from the third party who caused the injury, as long as you can prove negligence, then you're entitled to collect under workers' compensation. The difference being you keep what you're entitled to collect above and beyond what you've already collected.
That's pretty interesting. So also when we've talked about personal injury in the past, we've talked about product liability being an issue. And that certainly you can see where that might occur in the workplace. Someone uses a piece of equipment and they cut their fingers off because of the equipment, or they cut their fingers off, and then you want to say maybe it's because the product was defective, it wasn't labeled properly, it wasn't maybe used properly. I can see how that could certainly expand the nature of what would be a workers' compensation case, namely that someone hurt themselves on the job. Care to comment on how that goes?
It would expand not really the nature of the workers' compensation case, but
the
the
other
third-party case. And we've handled lots of different cases that raise a lot of different issues when you're looking at these things. So to tackle first what you raised, the product liability case, of course, over the course of many years, in Rhode Island in particular, where the Industrial Revolution was sort of forged, people would get hurt in factories, and many times there were machines that were made for use in the factory, made by somebody else. Sure. And so the question would become, was that machine altered by the place where you were working, or was it being used the way it was designed and installed and you didn't change anything? In other words, a lot of times they would say, well, did you take off a guard so you could work faster? Or did you alter the machine in some way to do more of what you're trying to do versus what it was designed to do? But we would have those cases, and if the machine, we'd hire an expert to look at the machine, and the machine was being used the way the machine was designed to be used, and as a result of a negligent design of the machine or a defect in the machine or some other thing that you could prove, you would be able to sue the manufacturer of the machine or the distributor of the machine and recover your personal injury as the result of the defect in the product, which would be considered a product liability case.
Okay, let's talk a little bit about how the scenario plays out. Initially, if someone's hurt on the job site, let's stay with that for the moment. Initially, their first reaction is got to go to the hospital, obviously. Then, if they are well enough to leave a hospital or well enough to make a telephone call, does that next call have to be the one that they place to a lawyer versus the workers' compensation claims department likely reaching out to them? What should happen first? Do you suggest that they not talk to someone in the workers' comp department before talking to a lawyer? Why or why not?
So here's what usually happens. You're hurt at work. Your employer knows that you've been hurt at work because they're there, or someone who you report to in management is there. Many times it's the management or your supervisor or somebody, or if there's a bigger company with human services or human
Yes.
resources department, they'll take you to the hospital if it's that type of injury that requires something to be looked at like that. Or even bigger company may have on-site medical attention or medical dispensary of some type where they can look at you. But certainly you need to let your employer know one way or the other if you've been hurt at work. Sometimes the injury is such that it's not a traumatic injury, but a repetitive use injury or something that comes up over time. And so when you know you've been injured as a result of work or some situation at work that caused the injury, you need to report that to your employer right away. You should also speak to an attorney, because remember, in workers' compensation, the way the system is designed, you don't pay your attorney's fee. If an attorney represents you and recovers your comp for you that they're disputing and you have to go to court to do that, or workers' compensation, claims counsel, whatever it is in Massachusetts, the insurance company or the employer pays the employees lawyer's fees. So you're not paying out of pocket. So it's because the court, the government, the legislation that's been put in place for workers' compensation wants you to be on an even playing field. And the insurance companies used to being on this playing field all the time. That's what they do. You're new, you haven't been hurt, you haven't been through this process before. Have an attorney who's been experienced in doing these types of claims take you through the process. So not only are you entitled to collect what you're entitled to, but you make sure you get all the benefits you're entitled to. Because we've talked about wages and medical bills, but we haven't talked about some of the other things like loss of use and disfigurement and where you're entitled to some of that as well.
And honestly, when someone is initially hurt, how could they possibly have the foresight to anticipate what else that could mean for them? Loss of use permanently, can't do their job, whatever that's going to be. Another point I'd want you to comment on, David, apparently within the workers' compensation situation with an employer who has workers' compensation insurance, he has or they have their own physician. So there's something there that just seems to be not quite, what did you say, on the equal playing field. Right. I would think that you would want to, even without having or needing a lawyer's advice, see the wisdom in getting an independent right. physician checking you out.
So you're entitled to pick your own doctor. And the doctor you pick in workers' compensation can be very important, not only to make sure you get better, but also someone who's used to dealing with the ins and outs of what needs to be reported and how they report your progress to the insurance company or the court, and to be able to testify on your behalf at court. So picking that doctor initially is very important. It's also, what you're referring to, going to become necessary at some point in time for you to see what the insurance companies might call an IME, or independent medical exam, but what we might refer to as an insurance medical exam, because they're doctors hired by the insurance companies. And so if that happens, what happens if your doctor says one thing and the insurance doctor says another thing? Well, the court can appoint an impartial medical exam too. And so that is something that you need to have an experienced attorney with to know, all right, well, here's your doctor, here's this other doctor, who might be best for you to see and weigh in with the court on deciding who's the best doctor for you to see for the court-appointed impartial exam. So those are all things that need to be thought of and dealt with early on in your workers' compensation case, so that you're not behind the 8 ball before you even start.
And also, when you go to a doctor, I'm sure there have been times when many of our viewers have gone to a doctor, and right at the outset, on the intake form, is this a workers' compensation related case? So I don't want to be cynical, but the other side of it is, as I've read and done this research here, it seems that there are some fairly strict protocols relative to communicating with your employer and having documentation. Address that?
Yeah, and also how the doctor's going to get paid, because the doctor has to know he's getting, or she is getting paid through a workers' compensation insurance payment, and not through Blue Cross or some other type of payment. So it's important for the doctor to understand that you've been hurt at work. So number one, they have to document their case to have the history of how you were hurt, so that down the road there may become a time where they're going to get cross-examined in a deposition by the insurance company lawyer to say, well, is this work-related and what history do you have? So the history that the doctor gets early on is very important so that they can document your case as it progresses. And is the type of injury that they're treating you for related to this history that they received? And the causal connection has to be done to a reasonable degree of medical certainty. So there's a lot of importance on the medical side really one of the most important things on the medical side is the doctor understanding the history so that he or she is able to back you up in saying that your injury and your diagnosis and your prognosis are all related to that injury that's been related to them through the history you gave them.
Okay, let's carry this a little bit further in a slightly different direction, which is, so there's not an accident, but rather you have shoulder problems. You can't move your neck, your shoulder, your hand, whatever. It's not the obvious, it's not an obvious accident as you referred to a repetitive injury.
Yeah.
How do employees say, this is just and only the result of my work for you? I work at a desk and I run with computers and calculators all day long, but I'm also doing that at home. How does that kind of case play out? I can see where it certainly would be, as I said earlier, complicated. How do you address that?
Yeah, so for example, carpal tunnel, which is going back to typewriters, remember those things, and now computers and keyboards and repetitive use of the hands. Or in certain cases, jewelry manufacturers are people who are putting jewelry on cards. And keep using their hands for that.
Yeah.
So again, the history of what your job is and the job duties is really important for the doctor to have in trying to diagnose what the injury is. And sometimes you could have arthritis, for example, and it's an underlying condition. And people can live with arthritis without having any symptomology or problems from it at all, but now there is a traumatic injury at work that sort of, we use the term, lights up the underlying arthritis, and now it's problematic and you have problems to the extent you can't work anymore or do your work. And so a doctor has to understand how an injury or a traumatic injury can light up an underlying arthritic problem or other problem of that nature and be able to explain why it's work-related as opposed to being something that is related to your own medical condition or physical condition or something else that might have caused it.
Interesting. And so now, not just because of COVID, but the tendency now is that so many people can work remotely. What happens to the typical workers' compensation case, as you're talking about, whether it's carpal tunnel or I just haven't had the right setup in my office and I'm having shoulder pain, which then ends up being tendon and ligament, and it could go on. How does that, all of that get proven? Does that play out, and does that make for more lawyers to have more cases?
It's going to be really interesting. So if you're working at home, but it's work hours, and you're working on a computer that either you own, because that's how you're set up with your employer, or they own, I don't think it really matters which you're using as long as it's during working hours and you develop a repetitive type of injury, or let's just say you fell at home while you were on your work going from the computer room where you're working to the bathroom and back. Is that work-related? Is it going to be compensable under workers' compensation law? And the argument would be if it's during the course of your employment and you're doing something in the furtherance of your employer's interest, then it's going to be work-related whether it happened at your house or not. Just like that CNA that we talked about at the beginning of the case who was going from one client to the other and got rear-ended between jobs. So as long as we can prove that it's out of the course of your employment and it wasn't some kind of, what was the term we used to use, frolic and detour from your job. So that same visiting nurse stopped at her daughter's school play before she went to the next place. Maybe that's not part of your job. But if it is part of your job, it will be compensable even if it happened at your home.
So more people who are working at home are working more and longer hours. Do you think that there are going to be more workers' compensation related cases? And part two, does every employer have to have workers' compensation?
So part one, probably the same number of cases, because you are just as likely to get hurt at work in the office as you are at home, I think. And part two, yes, you have to have workers' compensation insurance. It's required if you have employees. And if you don't, there's a criminal penalty, there's other penalties, there's all sorts of things that you're going to be facing. Now, some employers, I should say, have chosen to become self-insured, but there's a process you have to go through in order to do that, and it's difficult. And you have to show that you're able to pay whatever claims may come forward and that there's a fund to do that. So you could be self-insured. However, you have to have insurance in one form or another.
And if you are an employer, we do see that there are many who are trying to change the status of their former employees to be now part-timers, or not even part-timers, just independent contractors,
Right.
because it saves them oodles of money. And now it seems that it would also save them from being under this situation of workers' comp, but then could they still be sued personally anyway? How does that play out?
So the difference between an employee and an independent contractor has always been a big issue
Yes.
in workers' compensation. And so it was oftentimes looked at, what control does the employer have over the person, whether they're an employee or an independent contractor. So if someone was coming into the employer's office and performing a job with the employer's equipment and then leaving, that was somewhat difficult to say that that is an independent contractor. Someone in the construction business who had someone coming to a job site and doing work and using the employer's tools and equipment and coming at the time the employer said they should come and leaving when they were told that it was time to leave, still probably an employee, not an independent contractor. But some contractor who is having someone come in to do plumbing in the house that they're doing, and they're bringing their own equipment and doing it on the times that they want to do it primarily, more likely you make an argument that it's an independent contractor. However, there are forms that can be filed with the Department of Labor where someone's designated as an independent contractor, and I think it's forms that are sent in by both the employee, who would otherwise be an employee, and the employer. And when you do that, know two things. Number one, that if you become an independent contractor and you're a person who you are hiring as an independent contractor gets hurt, and you or someone who works for you did something that was negligent, you now may be subject to a common law negligence case.
Are those difficult to prove?
Well, it depends. I mean, if you're at a work site and someone who's working for the contractor or what would otherwise be the employer operates the crane negligently or left materials, because remember there's usually a lot of materials left at a work site in a place that wasn't well marked, and someone gets hurt, you're going to have a negligence case which might be easy to prove and may become more expensive.
How about the icy roof that they probably shouldn't have been working on that given day? Who's
Right.
at fault?
Yeah, so that'll become another type of interesting question is, I'm an independent contractor, you've brought me to help work on the roof, I've slipped off the roof, I've got hurt, so they'll say, yeah, but you saw it was icy too, did you assume the risk, or are you comparatively negligent, or in Massachusetts, contributorily negligent? So those are all kinds of issues that could be a whole TV show.
And yes, and one other facet of this. So if someone comes to a lawyer and you are dealing with a workers' compensation case and there is, for some reason, denied. I don't know, I think we went over some of the reasons. They didn't file in enough time, they didn't have the right documentation, we're not sure whether or not it really was a work injury. What kind of next steps, or what's the protocol to appeal such a thing? Because I don't really hear too often about workers' compensation wholly being denied, but in part maybe because the total amount being not what someone wants, if not totally denied. What happens next, David?
There's a process, and there's a process where, here's one thing you have to understand, especially in Rhode Island, is if you're getting paid, that doesn't mean necessarily that your claim or your case has been accepted as a workers' compensation. You could be being paid on what's called a non-pred agreement, non-prejudicial agreement, and they can do that for a certain period of time. So I'm still going to tell you, go see a lawyer if you've been hurt at work. Don't care if you're getting paid, not getting paid, you need to go see a lawyer. They can make sure that you're being paid correctly, that your claim is properly documented. So now, if your claim was being paid under a non-pred and they stop paying, you have to file an initial petition for workers' compensation. There can be a pretrial on that. The judge will decide at the pretrial whether you should get paid or not paid. Either side can appeal for a trial. So there's a process for that. And just like any other case, except actually different from any other case in workers' comp in Rhode Island, if you lose at trial, you can then appeal to a workers' compensation appellate board that would hear the case before it might go to the Supreme Court on a writ of certiorari if the court wants to hear that.
Comment, if you will, on workers' comp when it comes to how an insurance company is likely to have this played out over a longer period of time until someone no longer is benefiting from the PT after the surgery's happened and they're paid a portion of their 2/3 or whatever it is of their
used to
wages.
be.
I don't know what it is, but I've read that somewhere along the line. And now it's getting to a point where they're not making any more improvements. They can't justify it and they want to close a case, and yet you have, say the client's yours, and you realize that this person, no matter how many weeks, months, or whatever they've done, PT, OT, they can't go back and do their job. What do they do, and how does that play out?
So you're saying someone's reached maximum medical improvement and they're not going to get any better, and they're still disabled, but are they totally disabled or partially disabled? So what is the gate in Rhode Island, for example, after 6 years or whatever period of time
6
you
years.
collect partial workers' compensation for? Is it a case that the insurance company should consider settling? Does the attorney for the employee think I can get you through what's called the gate and keep you on permanently? Those are all the risks and gambles that need to be assessed by attorneys who can look at the medical records, are familiar with what's required to get you through to make sure you get maximum compensation, and whether or not the insurance company feels this is a case that we think we probably should settle, and this is what we would be at risk for if we can get you off after that period of time elapses, and how much of that are we willing to pay you to settle the case.
To say that it is complicated is an understatement, and just in these half hour that we've had to explore this, it certainly seems that people can better understand why there could be a great difference in the cost for them time-wise and money-wise. Thank you for that information. We appreciate your tuning into The Law Matters, and as we tell you, stay tuned to The Law Matters. It matters to you.